Everybody in the vehicle was dressed to the nines.
If you were under the custody of the Washtenaw County Sheriff,
I was not. There was money for hair.
I was
not. There was money for nails. There was money for gold. I was dropped off at the hospital and they later tacked on charges just like the fleeing and eluding charge.
Not beat that out.
And that it's calling 2024 CR 008
people can't sustain that element.
State versus Imani, Renee Robinson. Can I have parties announced for the record? State.
Thank you very much.
Preliminary examination in this matter will be set August 19th, 2025.
Counsel, have you received all of the discovery and did you review it with your client?
I have. That is before me.
Find that the state is in compliance with discovery. Ms. Robinson, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
I will.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Parties
Counsel,
also.
do you waive the reading of the indictment?
One of the
state, are you proceeding on the indictment as presented?
Yes, Your Honor.
I will call
did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
To have the court do something that it normally would not do.
Two or more previous
The
convictions.
defendant has elected.
State jail felony range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. Did you understand?
Civil claim.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than your bargain for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea you were giving up those rights?
To determine whether or not
to give up those rights and enter into a plea in this case? Did you understand if the court would grant your application for deferred adjudication if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 2 years in the state jail facility and up to $10,000 fine?
Because I think that's precisely what he wants to have happen.
Provide you with any defenses? Do you believe she has a rational as well as a factual understanding of the charges against her?
Do
you believe she's currently competent and was legally sane at the time of the
turned over
offense?
to the office of
Ms.
General Counsel
Robinson, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
For me, and as well as the
Anyone
others that I
promise you
see that
anything
are
other
listed
than the
there,
plea?
they will deal
Are you
with that. They
satisfied
have
with the way you've
also
been represented?
filed,
Yes, ma'am.
it
Are you a
appears,
U.S. citizen?
Yes, ma'am.
Court will find that
and
the
again,
defendant
this
has
is all
knowingly
part
and
of
voluntarily
his,
waived her
what I
right
will
to
call
jury trial.
shenanigans to
Did you
shake
review the
this.
plea
He
bargain
has
page
filed
with your
against
attorney?
people
Did you
of
understand it?
Yes, ma'am.
According to the plea,
individuals
there's a $2,000 fine and the
without
state
specific
recommends community
reference
supervision. Did
in
you
the
understand that to be
Washtenaw
the
County
plea?
Prosecutor's Office.
Defense is at the plea. State is
I
at the plea.
don't.
It is,
as I
Your Honor.
view
Did you review the
what I
waiver of appeal
read,
paragraph
would
with your
not
attorney? Did
consider
you
that
understand it and sign it
any
in both
jeopardy
places?
upon their
Yes, ma'am.
objectivity.
Did you
in
understand by signing
this
that you're
case.
waiving your
So,
right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been such motions?
There have not.
At this point,
For clarification, is there an application for deferred or no?
No, there's not. I may have just,
Until I otherwise.
may have just grabbed the wrong form.
Prosecute.
Community supervision instead.
All
Can I
right, so
speak
with
on that
regard
note,
to
Your
the
Honor?
plea bargain agreement,
I will let you talk,
I did
but I'm
not.
not going to let you go on in some diatribe. I've got other things to do.
I've stood on my rights and I've stood on my beliefs this whole entire time, especially in the previous case, Your Honor. That complaint is well pleaded. It does affect multiple parties of
so
this
according to the plea
jurisdiction.
bargain agreement, punishment must be assessed at
Washtenaw
2
County
years
is a
in the
named
state jail
party,
facility.
and I do believe
There's
that
no
my
application for deferred adjudication, and the state is recommending
impartiality
community
and
supervision.
bias
And there's a
will be affected
$2,000
here,
fine. Did you
as
understand
it
that to
was
be
in
the
the
plea?
past,
Yes, ma'am.
before this
Is that the
complaint.
plea?
Yes, Your Honor.
The state
And
is
I
at the
do
plea.
request a change of
Outside the
venue
agreement, the state is
on that note
recommending
for
that your
both these
community
matters.
supervision be for a term of 2
Wish to
years.
raise
There'll
change
be a
of
tap
venue, you may
evaluation,
file.
I was at a
20
hospital,
hours
not
community
a
service
jail.
If
restitution,
you were
and no
under the
contact with
custody of the
Don and
Washtenaw County
Vince.
Sheriff.
I was
Did you
not.
understand those were recommendations
I
from the
was
state,
not.
and the court does not have to follow those
Custody of-
I was
recommendations?
dropped off at the hospital
Then
and
to
they
the
later tacked on
offenses
charges
charged, how do you
just
plead
like the
guilty or
fleeing
not
and
guilty or
eluding
no
charge.
Not
contest?
beat that out,
State any evidence?
and that
The
if
state offers
that's
states
true,
exhibit number 1 in attachments.
No objection.
and
State
the
you may be
people
excused.
can't
Thank you.
sustain
Did
that
you review
element,
the
then
waiver
the
and
charge will be
stipulations with your
dismissed, but I'm
attorney?
not
Did you
dismissing
understand
it
it and
upon
sign
your
it in all the
representation.
appropriate places?
Thank you very much, Judge.
Again,
Preliminary
did you understand
examination
you
in
have a
this
right
matter
to jury
will
trial?
be
A
set
right for you or your attorney to
August
cross-examine and
19th,
confront any
2025,
witnesses. The state will call in the right to
12
remain
noon.
silent.
Yes,
That
ma'am.
is
Did you
before
understand
me
that today the state will be presenting evidence in the form of witnesses'
on
statements
that
and police
date.
reports? But most importantly,
for
there will be
both of
no
these
live
cases.
testimony. Did you understand?
I
Court will find
will
that defendant has willingly and
apprise
voluntarily
the
waived and consented to stipulation of
parties
testimony and
also
stipulations.
that
Court will accept
one of
into evidence
the,
states exhibits 1 and attachments, and the court will
I
review the
will
same.
call it
All
one
right,
of
after
the
reviewing states
activities, and I
exhibits
think
1 and
it
attachments,
is
the court will
a
find there is sufficient
maneuver
evidence to
to
find you
have
guilty,
the
and the court will
court
find you
do
guilty.
something that it
Are you
normally
proceeding with
would
sentencing?
not do.
Yes, Your Honor.
Anything you want to say on
The
behalf of your
defendant has
client?
elected,
Your Honor, it's been some time since
and I will disclose it, to
since something happened recently.
file
She
a
is in a better place now in her life. She's employed.
civil
She's
claim
9 months pregnant.
as against me and
About
a slew of other parties.
she's in a good place, and she can,
Oh, yeah, in that regard, Your Honor, I'm
As one
Many
girl
of
has said,
those
we'll
do
definitely
not
comply.
interrupt me,
All right, so this is the 3rd time she's probably learned her lesson for
including
stealing. Why
many
do you
that
keep stealing?
I don't even know the connection. Court has,
Before I wasn't in a better
this
position
judge,
than what I
if
am
I'm
now,
receiving
and
this,
that was something that I picked up in
two
a bad
things. I
habit.
read through the
Listen to
complaints,
this
determine
answer.
whether or
She
not
calls
it put
felony
on its
theft a
face
bad
created
habit,
conflict.
like biting your
Court,
nails. She
I
claims she was
consider it,
struggling
quite
to pay
frankly,
rent.
a
But hold on,
frivolous
Judge Boyd is about to
complaint
expose the
itself.
massive hole in that story.
Do not
What, a
see
bad
that
habit
as a
of stealing?
necessity for
Yes.
me to
How do you
use
develop a
myself from
habit
this
for stealing?
gentleman's proceedings, because I think that's
It
precisely
was
what he
just something
wants to
that
have happen,
I chose to do
and that
it
he's
choice.
attempting to manipulate.
And
But I mean,
now
I'm
He
just
will
trying to
be
figure out how
dealt
do you
with by
develop the
me as
habit
I
for
deal
stealing?
with any other defendant, and so
I don't. I mean, it just
Um,
happened.
that
You
is
know,
there. It has been
and-
turned over
Well, I
to
mean,
the
did you
Office
all
of General
plan?
Counsel
Did you
for
all say,
Washtenaw.
hey, let's go to
Washtenaw
Don and
County, they
Ben's
will
and take
deal with
tequila?
for me, and as well as the others that I
No,
see that are
it wasn't
listed there.
anything like that.
They will deal
like
with
I
that.
said,
They have also
I
filed,
was
it
in a
appears,
bad predicament, and
and again, this is
was
all part
using
of
that to,
his,
like, pay
what I will call
rent or
shenanigans to
do
shape
any- you
this.
know,
He
just
has filed against people of
making.
No, I don't know.
individuals
Because, and let me just explain to you why I
without
don't
specific
realize that.
reference
understand.
Because
in the
people
Washtenaw County Prosecutor's Office.
will spend
I
money
don't,
on their
as I
wants,
view
but
what
not
I
on their
read,
needs.
would not
And
consider
what I'm reading
that
in here, everybody
any
in the
jeopardy
vehicle was
upon
dressed
their
to the nines.
objectivity in
So
this
obviously,
case.
there
So
was money for clothes, there was money for hair, there was money for nails, there was money for gold, there was money for gold grills, but then people are saying they're stealing
At this
for
point,
other
we continue
things.
to
That
proceed with
I
this
don't
case.
understand.
Here comes the reality check.
Until
Judge
I
Boyd
otherwise
points out the
can be
obvious:
elected
the hair,
prosecutor.
the nails, the gold grills.
Can I
This is
speak
the
on that note, Your
definition
Honor?
of audacity. The
I
defendant
will let you
pleads
talk,
poverty,
but I'm
but
not
her
going to let you
appearance
go on in
screams
some
disposable
diatribe. I've got
income.
other things to do.
And then
I've
going
stood on
to
my
Don
rights
and
and I've
Ben's,
stood
the
on my
officer
beliefs
said
this
that the
whole
car
entire
smelled
time,
of
especially
marijuana.
in
And you
previous
all just
case,
went
Your
to
Honor.
Don and Ben's grabbing
That complaint
tequila.
is well pleaded.
So I don't understand when
It
people
does
say,
affect multiple
oh,
parties
I needed
of
Brent. Who's out here
this
buying stolen
jurisdiction.
tequila?
I don't
Washtenaw
smoke,
County
so
is
I
a
don't
named
know.
party, and
No,
I
I
do
said,
believe
who's
that
out
my
here buying stolen
um,
tequila? Did you take orders
impartiality
where you just
and
say, hey,
bias will be affected
anybody
here,
want tequila? Because it's
as it
saying that
was in
you
the
took
past before this complaint. And I do request a change of venue on that note for both these matters.
If you wish to raise change of venue, you may
Reposado.
file.
I was at a hospital, not a jail.
And
You were under the custody of the Washtenaw County Sheriff.
I was not.
As I understand.
I was not.
so that you all could drink and have a good
Custody
time.
of
I was
How-
dropped off at the hospital and they later tacked on
And
charges
I was
just like the
also
fleeing and eluding charge.
Not
And that
meet
was just
that
how I
out,
was making my money.
and that if that's true,
There's no excuse for it. I'm not
and
making
the
no
people
excuse for it.
can't sustain that element,
like I
then the
said,
charge will be
that's something that
dismissed,
I'm
but I'm
not
not
doing
dismissing it upon your representation.
Thank you very much, Judge.
Preliminary examination in
And the
this
people
matter
you were with,
will be set
this Latasha Bateman,
August 19th,
Latasia
2025,
Bateman, who is that?
12
Just
noon.
a friend of mine.
That is
Or was a
before
friend of
me.
mine.
All right, and who is this? They, I guess their mom named them
On
T.I.
that
Era
day.
Barber.
For
Yes.
both of these
that?
cases.
Just another friend.
I will
What does T.I. stand for?
apprise
Is that their
the
name,
I
T.I.?
think it's T-Era.
parties also that
The officer
one
didn't
of
put an
the,
apostrophe. Okay.
Right.
I will
All
call
right, court is
it
going to
one of
sentence you
the
to 2
activities,
years
and
in
I
the state
think it
jail
is
facility,
a
suspended and
maneuver
probated for
to
3 years.
have
If you were
the
drug tested
court
today,
do
what would
something
the
that it
results be?
normally would not do.
Okay.
The
There's to be regular
defendant has
UAs,
elected, and I will
regular
disclose
reporting
it to
by Zoom or
file
in person.
a
Are you employed?
Yes, ma'am.
What do you do?
I work for
civil
home.
claim as against
Doing
me
what?
and a
Pretty much
slew of other
assistant
parties.
I'm with
What does that mean?
Oh, yeah, in that regard, Your Honor, I'm
Many of those do not interrupt me,
Change clothes.
The credential or like
including many that I don't even know the connection. Court
No, you
has
go into people's homes and do
this
this?
judge,
I don't
upon
allow people on
receiving this,
probation in this.
Actual, it's like a
two
nursing home.
things.
It's
I
not just
read
like a
through the
home.
complaint to determine whether or not it would on its space create a conflict.
So she doesn't.
Or
So I don't go
I
into people's
consider it,
houses.
quite frankly,
It's
to
a
be
actual
frivolous.
facility.
This is
Plain itself,
terrifying. A habitual thief
do
taking
not
care of
see
the
that as a
elderly and
necessity
vulnerable.
for
This is where
me
the
to
justice
recuse
system
myself from
steps
this
in to
gentleman's
protect the community.
proceedings, because I
Judge
think
Bullard
that's
isn't just
precisely what he
sentencing a
wants to
criminal.
have
She's
happen.
preventing the next
And that
victim.
is
All
attempting
right, I'm
to
not going to allow you to
victims.
continue to work there
He will
unless
be dealt
I
with by
receive a
me
letter
as I deal with
from
any other
your employer
defendant. And
stating
so
that they know
that
what
is
you're
there. It
charged
has been
with,
turned over
and
to
you
the
can still
Office of
work
General
there.
Counsel for the
And
Washtenaw.
then the people that you're
Washtenaw
taking
County,
care of,
they will deal
they
with
either need to
for
sign
me
something
and as well
or
as
their
the others
relatives
that I
need to
see that
know
are
that you're
listed
working
there.
there.
They
All
will
right,
deal
and their
with that.
relatives
They have
need to know
also
that you're working
filed,
there.
it appears,
That's, Ms. Abrams, that's
and
what I'm
again, this
ordering.
is all part of his,
So
what
proof
I
of
will call
employment within 30
shenanigans to shape
days.
this. He has filed against people of
No employment with minors.
individuals without specific reference
So I don't know if you might.
in the Washtenaw County Prosecutor's
30
Office.
days out.
I
Oh,
don't,
just speak
as
to
I
probation about
view
that. I
what I
consider
read,
myself to be
would
reasonable.
not consider that any jeopardy upon their
I
objectivity.
appreciate
in this
30 days
case.
from
So,
2 weeks and then.
Oh, trust me, probation will say she's on maternity leave. And I'll say, okay. There's to be no employment as a home health care provider in someone's residence. And also, she's not to be a home health care provider at a facility.
Can I speak on that
without
note, Your
a
Honor?
letter from the employer stating
I will
that
let you
they're
talk,
aware of her
but I'm not
criminal
gonna let you
history
go on in
and
some
she's allowed to
diatribe.
work
I've got
there.
other things to do.
And
I've
the
stood on
family
my
members
rights and
of
I've stood on
whoever
my
she's
beliefs
caring
this whole
for
entire time,
is aware
especially
of a
in
criminal
previous
history,
case, Your Honor.
and they have no
That
objection to their
complaint is well
working
pleaded.
there. Field visits one
It
time per
does
month
affect multiple
for 3 months.
parties.
200 hours of community
this
service
jurisdiction.
restitution. I'm going to order parenting
Washtenaw County
classes.
is a
Once the
named
parenting
party,
classes
and I
are
do believe
complete,
that my
100 of those hours will be waived.
impartiality
I'm gonna order the
and
theft
bias
course. Once
will be
that's complete,
affected
the
here
remaining hours will
as
be
it was in the
waived.
past before this complaint. And I
Probation,
do
is there anything
request
else?
a change of venue
Is there anything
on
else you
that
need from the
note for
court to be
both these
successful?
matters.
No, ma'am.
All right, did you
Wish to
review the
raise
document
change of
entitled trial
venue,
court
you may
certification
file-
I was at a
of defendant's
hospital,
rights to appeal
not
with your
a jail.
attorney?
If
Did
you
you
were under the
understand it and
custody
sign
of the
it?
Washtenaw County Sheriff's
I was
Office,
not.
Oh, and I'm sorry, just
understand.
one other
I was
thing.
not.
There's to be
Custody of-
no
I was dropped off
contact
at the hospital
with
and they later tacked on
And
charges
you know
just
what?
like the
The
fleeing and
evidence
eluding charge.
Lastasia,
beat that out. And that if that's true,
Lastasia, Bateman,
and the people
Batman,
can't sustain that element, then the
and
charge will be
Tiara,
dismissed, but I'm not dismissing it upon your representation.
RRA,
Thank you very much, Judge.
Preliminary
Barber,
examination in this
Right,
matter
because it's
will
plea
be
bargaining
set
agreement, because I followed your plea
August
bargaining agreement,
19th,
and because you waive your right to
2025.
appeal, you do not have the court's
12
permission to
noon.
appeal. Do you understand?
That is before
All right, good
me
luck to you. If you need anything, let probation know. If you feel as though they're not addressing,
on
you can
that
always come
date
back to the court.
Thank you.
All right, you're
for
welcome.
both of these
Just remain in
cases.
court probation. We'll go over conditions.
I will
Fast forward 1
apprise
year. The baby has been born and the second chance has been
parties
blown.
also
She didn't just miss a meeting,
that
she
one
vanished
of
for
the-
6 months.
Court is calling 2024.
I will call it one of the activities, and I think it is a maneuver to have the court do something that it normally would not do.
Are you Miss Robinson?
The defendant has
Did you review the
elected,
documents entitled motion to revoke community
and I will
supervision?
disclose
Motion
it
to revoke community
file
supervision-
a
to revoke community supervision with your attorney. Did you
civil
understand?
claim
Are you
as
the
against
same
me
Amani
and
Renee Robinson,
a
who was placed
slew
on
of
community
other
supervision
parties.
2024 CR 008.
Oh yeah, in that regard, Your Honor, I'm
663
Many
for
of
the
those do
offense
not
of theft of
interrupt me,
property less than $2,500 with 2 or more convictions.
including many that I don't even know the connection. Court has, this judge, upon receiving this, 2 things. I read through the complaint to determine whether or not it would on its face create a conflict, or I consider it, quite frankly, to be frivolous, plain itself. do not see that as a necessity for me to recuse myself from this gentleman's proceedings, because I think that's precisely what he wants to have happen.
Did you understand by pleading true to violation of condition number 4, the court could
He will be dealt with by me as I deal with any other defendant, and so that is there. It has been turned over to the Office of General Counsel for Washington County. They will deal with for me, and as well as the others that I see that are listed there. They will deal with that. They have also filed, it appears, and again, this is all part of his, what I will call shenanigans to shape this. He has filed against people of individuals without specific reference in the Washington County Prosecutor's Office. I don't, as I view what I read, would not consider that any jeopardy upon their objectivity in handling this case. So.
Jeff, I spoke with a man regarding yesterday. She would likely have
at this point we continue to see this case.
So instead of doing
until I did otherwise,
what you should have done first, we're here now in this motion.
Can I speak on that note, Your Honor?
Not reporting.
I will let you talk, but I'm not going to let you go on in some diatribe. I've got other things.
I've stood on my rights and I've stood on my beliefs this whole entire time, especially in the previous case, Your Honor. That complaint is well pleaded. It does affect multiple parties of this jurisdiction.
You have to be kidding me.
Washington
Her
County is a
excuse for
named party,
ignoring the
and I
court is
do
that she
believe that
committed
my
another crime and didn't want to get caught.
impartiality
That is the height of
and
entitlement.
bias
She thinks her
will be
fear of
affected here,
consequences is a valid
as it was
reason
in
to
the
ignore
past
the law.
before this complaint. And I do request a change of venue on that note for both these matters.
If you wish to raise change of venue, you may file.
I was at a hospital, not a jail.
If you were under the custody of the Washington County Sheriff's
I was
Office,
not.
I understand.
I was not.
Custody of.
I was dropped off at the hospital and they later tacked on charges just like the fleeing and eluding charge.
Not meet that out, and that if that's true, and the people can't sustain that element, then the charge will be dismissed. But I'm not dismissing it upon your representation.
Thank you very much, Judge.
Preliminary examination in this matter will be set August 19th, 2025, 12 noon. That is before
We're
me.
back on the record in 2024 CR 008-663.
For both of these cases. I will apprise the parties also that one of the,
The moment
I will
of
call
truth,
it
the judge
one of
offers
the
a hard
activities that I
reset or
think
a hard
it
time.
is
Most
a
people would fight for
maneuver
their freedom,
to
but watch
have
this.
the
She
court do
chooses the
something
jail
that
time.
it
She'd
normally
rather sit
would
in a
not
cell for
do.
nearly a year than follow the rules of
defendant has
society.
elected,
Oh, do you have the,
and I will disclose it,
can I
to
have a trial court certification?
file
please?
a civil claim as against
Court is
me
finding
and
violation of condition
a
number
slew
4-2.
of other parties.
Court will
Oh, yeah,
send
in that
to
regard, Your Honor, I'm
Many of those do not
Court will
interrupt me,
revoke. Send it to
including many that I don't
300
even know the
days
connection.
in
The
their
court
county jail.
has, this judge, if
1244.
I'm receiving this,
Give you credit for any time
two
served.
things. I read through the complaint to
There's
determine
been no
whether or not it
contact
would on its face
with
create a
Don
conflict.
and
Court.
Ben's,
I
B
consider
and
it quite
apostrophe
frankly to be
S.
frivolous.
There's to be no
complaint
contact
itself.
with
Do not see that as a necessity for
Talon,
me
I
to
believe it's Talon
recuse myself from this gentleman's proceedings, because I think that's precisely what he wants to have happen. And that is attempting to manipulate the system.
All right, is there anything
He
else with
will be
regards to
dealt
sentencing?
with by me as I deal with any other defendant.
All right,
And
consider the
so
document entitled trial court certification.
that is
of
there. It
defendant's
has been
right to
turned
appeal
over
with
to
your
the
attorney.
Office of
Did
General
you
Counsel for
understand it, and
Washington.
did you sign it?
For Washington
Yeah.
County, they will deal with
Yes or no? Did you
for
understand
me,
it?
and as well as the others
All right,
that
you
I
have a
see that are
limited right to
listed
appeal.
there.
That right to appeal
They
is
will
as it
deal
relates
with
to the
that. They have
allegations in the
also
motion, not the
filed,
fact that you're on community
appears,
supervision. Because this is a felony
and again,
conviction, you're
this
not
is all
allowed to
part
own or
of
possess
his,
any weapons
what
or
I will call
ammunition. If you have a question
shenanigans to
over what
shape
that
this.
is, you'll
He
need
has
to
filed
speak to an
against
attorney.
people
Do you
of
understand? All
individuals
right, good luck to you.
without specific reference.
Yes.
This case is a powerful example of how the justice system balances second chances with personal accountability. At the beginning of this story, the court was faced with a defendant who appeared sympathetic on the surface. She was heavily pregnant, claiming she had been struggling financially, and her attorney argued that she had turned her life around. In many courtrooms, those factors can absolutely influence sentencing decisions, especially when a defendant shows genuine remorse and a willingness to change. Judge Boyd initially chose the path of measured leniency. Instead of imposing immediate jail time for a repeat felony theft charge, the court accepted a plea agreement that suspended the 2-year state jail sentence and placed the defendant on community supervision. This is significant because probation is essentially the justice system saying, we believe you deserve an opportunity to prove you can live within the law. It's a structured second chance, but it comes with strict rules. Those rules included reporting to probation officers, maintaining lawful behavior, completing community service, and complying with court-ordered conditions. None of these requirements are unusual. In fact, they are standard expectations for anyone granted probation after a felony conviction. But this case took a dramatic turn after that opportunity was given. Instead of using probation as a stepping stone towards stability, the defendant disappeared from supervision for 6 consecutive months. In legal terms, failing to report to probation is one of the most serious violations a person can commit while on community supervision. Courts view it as direct defiance of the authority that granted the second chance in the first place. During the revocation hearing, the defense essentially argued that the defendant stopped reporting because she feared being arrested for another issue. But ironically, that explanation highlights a key truth in probation law: avoiding the system almost always makes the consequences worse. Judge Boyd then offered what might have been the final lifeline, a choice between continuing probation with a short 30-day jail sanction or accepting a much longer jail sentence through revocation. This kind of option is sometimes used by judges to test whether a defendant truly wants to correct their behavior. And yet, in a moment that stunned many courtroom observers, the defendant chose the 300-day jail sentence instead of remaining on probation. Legally speaking, once that decision was made and the violation was found to be true, the judge had clear authority to revoke probation and impose the custodial sentence. The result: 300 days in the Bexar County Jail. Cases like this raise important questions about personal responsibility, rehabilitation, and the limits of judicial patience. The court did provide an opportunity for reform, but ultimately the defendant's own choices determined the outcome. It's also a reminder that probation isn't simply a lighter punishment. It's a contract between the court and the defendant. When someone violates that agreement repeatedly or refuses to comply, judges often have little choice but to enforce the original sentence. Now the question shifts to you. Was this a fair outcome? Did the judge give enough chances, or perhaps too many? And what do you think about the defendant choosing almost a year in jail instead of following probation rules? Drop your thoughts in the comments below. This is one of those cases where people have very strong opinions. And if you found this courtroom breakdown fascinating, make sure to hit the like button, share this video with someone who loves real courtroom drama, and don't forget to subscribe for more jaw-dropping legal cases and justice system breakdowns.